to be done by the executive and wants no window for public participation by parliament, and I have a problem with that. Mr. Speaker, Section 53, and this is a bit technical, but you'll understand it.
Honorable Otiende Amollo, you know, whenever you speak, the House goes quiet. Is there business that can be transacted by Parliament that does not involve public participation?
That is my submission.
If we consider the provisions of Article 118.
Let me answer it in this way. And that is, what you've said is my exact concern. That Section 20 of this bill gives the Cabinet Secretary the discretion to do public participation. When it comes to Parliament, then, Section 23 restricts Parliament to 60 days. The point being this: in my view, that restriction will constrain the ability of Parliament to do public participation. That is my submission. And that then becomes unconstitutional.
Yeah, it will constrain Parliament in terms of time.
Yes.
But it cannot take away the obligation imposed on Parliament by Article 118, which I may read. I'll freeze your time. That Parliament shall conduct its business in an open manner, and its sittings and those of its committees shall be in public, and facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So privatization at that level becomes other business of Parliament.
Everything you've read amplifies my argument.
Thank you.
And this, it is in twofold. One, that while Section 20 provides an avenue for public participation expressly by the Cabinet Secretary, there is no corresponding section that expressly provides for public participation by Parliament. That's the first limb. The second limb is that by restricting the time to 60 days, and you know how public participation works, it may interfere with the duty of Parliament to do public participation. And that is my problem with those two sections.
Thank you,
I now come
Honorable
to my last submission.
Thank you, Honorable
My last submission is this.
Yes.
In relation to Section 53.
No, Honorable Amollo does not want information from you, Mover.
No. Mover, that's why I wanted you back. Take notes keenly, and then when you are replying, you will be able to respond.
I have heard Honorable Amollo Mover to be saying there could be amendment to the period.
But that is why I started.
Parliament.
Mr. Speaker, I started by saying this. But
yes,
what is the point of order?
You can also freeze this Honorable Otiende's time, because I just need...
Honorable Otiende, I will not
because
freeze your
time. The issue Honorable
Otiende
is raising, Honorable Speaker, and you have alluded to it, is critical on public participation. And you have clearly read the provisions of Article 118 of the Constitution. I just wanted Honorable Otiende to help the House as a senior counsel. When the Constitution explicitly provides for public participation, that Parliament must conduct public participation on any legislative proposal. An act of Parliament can never negate that, and that is my understanding of basic law. And I'm not a student of law. That's why I wanted Honorable Otiende to educate me and the House and Kenyans whether the absence of that explicit provision in this statute or this proposed statute negates that which is provided for in the Constitution. Because my understanding, Honorable Speaker, from what you are saying, is that it does not negate, and Parliament will be obligated, as we do with all other legislative proposals, to carry out public participation. Just that clarification.
Honorable Otiende Amollo, because you are in the committee of experts only, otherwise you owe the mover no obligation of education.
Yes, indeed.
Yes, so proceed.
Indeed. And you know, indeed, Mr. Speaker, we allow the mover that discretion, but that is not a point of order. That is a point of argument. But let me now then explain what the problem is. Slowly. Two things, Mr. Speaker. One is that because the Constitution provides for public participation, you may not need to expressly provide for it. But then the question is, why then expressly provide for public participation by the Cabinet Secretary? And public participation is required not just by Parliament, it is required by all organs. So because the Constitution does not require it, why would you provide for the Cabinet Secretary and not for Parliament? That's the first problem I have. But the next problem I have is the time constraint. Because Parliament should be left the discretion to do sufficient public participation, when you constrain its time to 60 days, then you might actually be constraining that duty, and that is my problem. So if you ask, just so that I answer.
Honorable Amollo, you are understood.
Yes.
In fact, you are saying the same thing with the mover, except you are speaking at cross purposes.
Yes, because
the mover is saying...
I'm educating him in law.
Yes. The mover is saying, if I understood the mover well, that while least public participation is provided for in Article 10 as a national value, the Constitution specifically mentions it for Parliament, but does not for the executive. And so the mover is saying for the executive, the bill may need to propose it specifically, but for Parliament, according to him, the bill does not, because Article 118 already does so.
And it's wrong.
But that does not take away your power to amend and to make it better.
And here, Mr. Speaker, the mover is wrong, and that's what I'm trying to explain. But I may need a whole day to explain this. My whole point is, to constrain Parliament to 60 days is a constraint on the duty of public participation. And we would do better to remove that time constraint. In very simple parlance, that's what I'm saying. But let me now come to my last point, Mr. Speaker, and this is a little technical, and I would not blame the committee for this, Section 53, where we establish an appeals board. Now, the design is good because you start with a review, then appeal to the appeals board, then to the High Court. And that design is good.
You will add, Honorable Amollo, how long do you need? 2 minutes. Yeah, I will add you 3 because of my own interventions also.
Thank you. The only technicality, and this is beyond this act, is to advise the committee that as we speak, there's a decision of the High Court, of the Court of Appeal, that moves all these tribunals to the judiciary. And in that context, to establish a tribunal whose appointment is entirely by the President and the Cabinet Secretary is one that might require re-examination. And in fact, as we speak, the legal team in this House, including the Speaker, are grappling to persuade the court that there's room for administrative tribunals and judicial tribunals. But for now, that is the law. And therefore, as framed, Section 53 may be in danger of being unconstitutional. Lastly, Mr. Speaker, we must ask, our order paper number 13, which I think was a supplementary order paper, and the leader and the House business owe us an explanation. When we looked at the order paper this morning, order paper number 13 was not about privatization. And some of us did not come to the House for that reason. When we come, we now find there's a different order paper for approval of a privatization based on a sessional paper, when the very next order is approval of a bill that regulates privatization. What is this thing of legislation by ambush? It is something we must object to, and it is something that must be corrected. Thank you, Mr. Speaker.
Thank you, Honorable Amollo. Honorable Amollo, the business of the House is determined by the House Business Committee. And there is something called supplementary order paper, so we must always be vigilant. Yes. The Honorable Benjamin Langat will now speak.
Mr. Speaker, thank you for giving me this opportunity.
Order, honorable members. Order, honorable members. The mover, the leader of majority, take very seriously the last point raised by Honorable Amollo. And by the way, I know some amendments speak to it, Honorable Amollo, in terms of realigning, those provisions. But I think Honorable Amollo also look at the distinction between the privatization proposal and the privatization program in terms of their contents. And then you can make proposals in terms of how to improve. This bill, you both agree, is a good bill. Honorable Benjamin Langat, proceed.
Thank you very much, Mr. Speaker, for giving me this opportunity to contribute to this bill. Mr. Speaker, as has been said, this is not a new bill. It has already been passed in 2023, but the courts annulled it. Mr. Speaker, the reason why it was annulled was because of lack of public participation mainly. And I want to inform the House that we have done very serious public participation, Mr. Speaker. Mr. Speaker, in fact, we went to 25 counties outside Nairobi, Mr. Speaker. So we have corrected the anomaly, and hopefully the bill will go through. Mr. Speaker, this bill seeks to repeal Privatization Law Act of 2005, and it creates a privatization authority to replace Privatization Commission, which, Mr. Speaker, had been affected by a lot of bureaucracy, Mr. Speaker. Imagine for the last 10 years, there has not been any privatization of any company in the Republic, Mr. Speaker. So, Mr. Speaker, hopefully this bill will make the process smooth, will make the process faster, and will make the process safer, Mr. Speaker. Mr. Speaker, this bill creates a privatization authority with a board. Number two, Mr. Speaker, it distinguishes the functions of different actors in the process. Privatization authority will do the implementation of the privatization process. The CS, Mr. Speaker, will initiate the process through what we call privatization program, which is basically the list of companies that have been identified for the purposes of privatization, Mr. Speaker. The bill also sets the fact that the CS will take the bill to Cabinet for approval, the program to Cabinet for approval, then it will be brought to Parliament for approval. And Parliament can approve as it is, can amend, or can reject, Mr. Speaker. If Parliament approves with amendments, then the Cabinet Secretary will have to publish a fresh list and